So another federal court ruled that the federal laws restricting machine gun possession are in fact a violation of the Second Amendment. But the Attorney General Bondi and the Trump administration are still appealing that decision, and they will likely continue to argue that these types of firearms and these items are not protected arms under the Second Amendment. So let's break down what is happening in this critical case. As I mentioned in the intro, in this video, we're going to be talking about a critical Second Amendment challenge that deals with machine guns. It deals with the Second Amendment, and this is a challenge currently in front of the Fifth Circuit Court of Appeals. Recently, another federal court dismissed a machine gun possession charge using the Second Amendment and the recent Supreme Court Bruen ruling. This decision came out of the Mississippi District Court, a federal court, and was issued by Judge Carlton Reeves in the case here that we're covering, which is called U.S. versus Brown. However, that ruling and that decision cited heavily to another case that came prior, and it's a case we've talked about in the past called U.S. versus Morgan. However, in both of these challenges, we have now seen that the Trump DOJ and Pam Bondi in her office continue to argue that these are not protected arms and that the restrictions that are included in the GCA are not a violation of the Second Amendment. Recently, the Morgan case went in front of the 10th Circuit Court of Appeals for arguments, and the Trump DOJ continued to argue against the Second Amendment and also the possession of machine guns. That will likely trickle into the Fifth Circuit's Brown case, since the DOJ appears to have an anti-machine gun policy in both of these challenges. Now, in this Brown case that we're talking about in the video, the lower court judge stated that, as Judge Brooms explained in Morgan, the statute criminalizes the mere possession of such weapons without regard to how the possessor uses them. If an individual purchases such a weapon and locks it away in a gun safe in his basement for 20 years without ever touching it, he is just as guilty of a violation of Section 922(o) as someone who takes the same weapon out in public streets and displays it in an aggressive manner. So there he's saying this just blanket machine gun possession ban, outside of the GCA's restrictions, the fact that they treat someone who has one of these items that just sits in their safe the same way as someone who takes it out and acts in an aggressive manner, that is not consistent with the Second Amendment. He went on to state that every appellate court's prior precedent was rendered obsolete, and he's talking about the fact that prior precedent on the 2A context has now been kind of overridden because of the Supreme Court's recent activity in Bruen, Rahimi, and some of these other cases. He states that under the new standard, the government must prove that its desired firearms restriction, which here means the statute criminalizing simple machine gun possession, is consistent with the nation's historical tradition of firearms regulations. This is a heavy burden, he stated. Now, the historical justification that the federal government presents to this whole machine gun possession issue in the prosecution of Mr. Brown include things like the statute of Northampton relating to the riding and going armed offensively to the fear and terror of good citizens, but the judge here in the lower court rejected all of that historical support. The judge pointed out that the record shows that there are more than 740,000 machine guns lawfully possessed within the United States as of 2021, and he stated that that is simply no small number, and the federal government really failed to explain how that high of a number of possession for lawful purposes is not in common use. So how can there be so many of these in lawful possession, and how does that not mean that they're in common use? Really, to contest that number of machine guns in common use, the federal government relied only on a prior Fifth Circuit case called Hollis, but the judge here in this case found that Hollis was no longer binding precedent because of Bruen, and also the Hollis case that was prior ruled on in the Fifth Circuit had only in the record about 175,000 machine guns in lawful possession, and now the number is way higher. Based on that, he agreed with Mr. Brown's as-applied challenge and granted his motion to dismiss the case based on the Second Amendment. Now, the U.S. government then decided to appeal that ruling up to the Fifth Circuit, and in this case, Pam Bondi and her DOJ are continuing to argue against the Second Amendment. In the Trump DOJ's recent brief, they argue that the lower court's decision was an error and that it needs to be reversed. They state that machine guns are not typically possessed by law-abiding citizens for lawful purposes. Instead, they are uniformly restricted, highly lethal, and well-suited for criminal misuse. Now, this is kind of standard anti-gun arguments that you would expect coming from maybe anti-gun states, but it's still being made and adopted by the Trump DOJ in this machine gun case. They claim that machine guns are dangerous and unusual weapons, that they're not in common use for lawful purposes like self-defense and other lawful conduct, and therefore they can be outright restricted or even banned. They also argue that Bruin's analysis did not override the Fifth Circuit's prior case in Hollis. They claim that nothing in Bruin unequivocally kind of specifically addressed Hollis. They didn't cite to Hollis directly in Bruin, and therefore they argue that that still stands binding precedent in the Fifth Circuit and should not be thrown away just because of the Bruin ruling. Now, Mr. Brown recently filed his brief arguing that the lower court got the analysis correct, and at the very least, the Fifth Circuit should hear oral arguments in his case. And this is despite the fact that you have the current Trump administration and the Trump DOJ arguing that this is not a case that the Fifth Circuit should even hold oral arguments on. So here you have Mr. Brown arguing that the Fifth Circuit should hold oral arguments in this case and address this machine gun possession issue, but you have the Trump DOJ saying, no, please don't review this. We don't need oral arguments. Just look at the papers and reverse the lower court. So the Trump DOJ wanted to skirt the oral arguments likely because they had to present recently some arguments to the 10th Circuit in the Morgan case on similar issues, but the likelihood is that the Fifth Circuit will require oral arguments in this specific case, and the Trump DOJ will once again have to walk out all their anti-Second Amendment positions that they, made similarly in the other case out in the 10th Circuit. So they're going to have to probably do the same thing here also in the Fifth Circuit. Also recently, multiple TOA organizations have filed a brief in support of the plaintiff here, in support of Mr. Brown, and they argue that the Fifth Circuit should uphold what the lower court said in that decision. In this brief of the TOA organizations, they state that, looking to history, the government is correct insofar as the only historical tradition the Supreme Court has identified that can justify an arms ban is on arms that are both dangerous and unusual. Thus, to meet its burden, the government must establish that the arms at issue are both dangerous and unusual. The district court correctly determined that the government has failed to do so here. Primarily, the government failed to demonstrate that the machine guns here in question are unusual today and instead sought to rely on decades-old dicta to meet a test rooted in today. Put simply, they state, regardless of one's view of the arms at issue, the government did not carry its burden in the district court. Accordingly, this court should affirm the district court's dismissal of this case. So this case is moving forward still, and the administration here, the Trump DOJ, is still arguing against machine gun possession. They're still arguing against the Second Amendment, and they still believe that these are not protected arms and that the lower court's decision should be reversed. Even worse, they argue that the Fifth Circuit should not even hear oral arguments in this case. Instead, they should just rule on the papers and the record and reverse the lower court. And really, I think this is to avoid them having to come into the Fifth Circuit during oral arguments and argue against the Second Amendment once again. However, Mr. Brown here argues that at the very least, the Fifth Circuit should hold oral arguments in this case, and I think that's exactly what's going to happen. I think the Fifth Circuit is going to hold those arguments, and the Trump DOJ is going to have to walk into the Fifth Circuit like they did the 10th Circuit and argue against the Second Amendment. So this is a critical decision, that was issued by the lower court, similar to what we saw happen also in another court. And now this is going to make its way to the Fifth Circuit. I think there's going to be oral arguments. And here you still have the Trump DOJ arguing against the Second Amendment. As this develops, as we get more information, I will let you guys know. If you like this channel and you want to support the channel, one of the best ways to do that, of course, is to subscribe to the channel. Also, you can check out my website, armedscholar.com. Over there, we have the free legal guide that you guys can get. All you have to do is put in your email and you get sent a PDF through the email. And then we do some follow-up emails to give you additional free information. And then also we have some deals over there, so you can check out some deals to save some money as well. But as always, thank you guys so much for all of your support. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.